Appearing
Yes.
with me, my Lord, are my learned friends, Olanike Dare Esquire and YD Abiri Esquire. For the claimants.
YD what? Who, sir?
Appearing with me, my Lord, are my learned friends,
Olanike Dare.
Dare Mrs.
Yes.
And YB Abiri.
Okay. Thank you, sir.
Claimants.
Thank you, sir.
Thank you, my Lord.
Yes. Any representation for the defendants?
Yes, my Lord.
Yes, please.
With profound respect, my Lord, my humble appearance is for the third defendant. Oh, with profound respect, my Lord, my name's Abimbola Marian Akinifesi.
Yes.
My humble appearance is for the third defendant, the Office of the Accountant General.
Do we have any representation for the first and second? Any representation? Sorry, I didn't hear that.
They are aware of the Zoom meeting. They're supposed to be aware.
Okay, so I'll record them as being absent.
Well, that should be it, my Lord, because they are aware.
No legal representation for the first and second defendants. Yes, the claimant counsel, please. Mr. Achimogu. The claimant counsel, please. Ms. Akinifesi?
Yes, my Lord.
Yes, can you proceed since we cannot contact with the claimant counsel again?
Okay. My Lord, in the last sitting on the 16th of March 2022, my
Yes.
Lord raised the issue of jurisdiction, Swomoto, and ordered all parties
at the last sitting?
On the 16th of March.
Okay.
2022.
Yes.
My Lord raised the issue of jurisdiction, Swomoto, and ordered all parties to address her on the issue of jurisdiction on the next adjourned date, on whether or not the jurisdiction of this court can be invoked on trade dispute matters.
Yes.
In compliance with that order, my Lord, I have filed a written address on the issue of jurisdiction.
With profound humility, my Lord.
Yeah, let her finish her submission. It's because we couldn't hear you anymore, so I told her to start. So since it's an issue of jurisdiction, it doesn't matter which order it is. It's okay, sir. So, Mrs. Akinifesi, can you continue, please?
Okay, my Lord, I have filed a written address. In compliance with that order, my Lord, I have filed a written address on the issue of jurisdiction dated.
When was it filed?
Dated 27th of April 2022 and filed on the 28th of April 2022.
Yes.
I adopt the said written address and the arguments therein conversed, and I urge your lordship to decline jurisdiction and strike out this matter.
Yes, the claimant counsel.
To profound humility, my Lord.
Yes, sir. Yes, I can hear you.
Yes, the claimants filed a written address.
Yes.
as ordered by your lordship on the 16th day of March 2022. It was filed on the 31st day of March 2022, within time.
On what date?
It was filed on the 31st day of March 2022.
Okay, yes.
My Lord, we seek to adopt the written address and the
Yes.
submissions therein as an argument on the issue of jurisdiction.
Yes.
My Lord, we further submit, my Lord, that the issue your lordship directed us to, ordered us to address you on, was on the issue of the jurisdiction of this court in relation to Section 48 of the Trade Disputes Act. But my Lord, in the written address by Counsel Malene Friend for the third defendant,
Yes.
he formulated two issues on jurisdiction, but formulated a distinct issue in issue 3.
The
On
third defendant's counsel formulated
issue 3,
a distinct
issue as issue 3,
yes.
on whether there is the action discloses any cause of action against the third defendant, which was not within the ambit of your lordship's order or direction on the 16th of March 2022. I therefore will be urging your lordship, most respectfully, in reliance upon Order 45, Rule 1, Rule 2, my Lord, Order 45, Rule 2,
Yes.
particularly the proviso thereto, that your lordship should discountenance the third issue on the issue of cause of action.
Order
Since it was not the
45,
issue
Rule
that
2.
Rule 2, the proviso to Order 45, Rule 2. Your lordship is empowered therein to discountenance any extraneous matter in the written address. My Lord, it provides that provided that where a written address contains extraneous matters, the court may discountenance the portion of the final address containing the extraneous matters. And I so humbly urge my Lord to discountenance this issue 3 in the third defendant's address.
Yes, sir.
My Lord,
Yes, I am aware too that the first defendant filed a written address. I hope it has been served on parties.
yes, my Lord.
Claimant counsel. Claimant counsel.
My Lord, we are even, as at today, we are here to receive the process of the claimant counsel. We haven't even been served.
I don't have such record before me. You know, I'm not on site, but I will
Yes,
let
my
them
Lord.
check and revert back to you. Revert to you.
Yes,
The
my
court
Lord.
is aware that the first defendant filed a written address on the 1st of yes, sir. Have you been served with the first defendant's written address?
Yes, my Lord.
Okay, the court is aware that the first defendant filed a written address on the 1st of July 2022. Same is deemed.
Outside the time.
Did I actually give you any time?
There was no time, my Lord. It's an issue of jurisdiction. There was no time.
No, I didn't give any time, sir. I'm just looking at the record.
Okay,
yes, so So the court is aware that the first defendant filed a written address on the 1st of July 2022, same is deemed adopted.
Yes, my lord.
My lord, sorry, because we had a break in the services. I had wanted to make a comment on the first defendant's written address.
Yes, sir.
My lord, the first defendant's written address, in the same vein as issue 3 of the third defendant, was exclusively on the issue of the local standing of the claimants to bring this application. I didn't make any effort to file any reply to it because it was not the issue formulated for us to address your lordship on. So I'll be most humbly urging my lord to also discontinue the content of the first defendant's written address, as it is not on the issue formulated by the Honorable Court, pursuant to Order 45, Rule 2, particularly the proviso thereto. Your lordship is entitled to discontinence once it is within, is not within the ambit of what your lordship directed you should be addressed on. Just on local standing. For him to do that, my lord, he ought to have filed a separate application.
Okay.
So I urge my lord to, I must go to my lord. I urge my lord finally to hold that this honorable court has jurisdiction to hear this matter. I must go to your lordship.
My lord?
Yes.
Looking at the subject matter of this suit, it ought not to have been instituted at the National Industrial Court at first instance, but rather as an appellate court having exhausted all procedures as set out by the Trade Dispute Act.
Yes.
By the nature of this dispute, my lord, the claimants were duly bound to approach the Federal Ministry of Labor and Productivity for a referral to the Industrial Arbitration Panel for an adjudication of the dispute between the parties.
Are you readopting your address, or it's a new issue?
And on the briefing, my lord.
Okay. So, I'll look into your written address and I will give the ruling, sir.
As the court pleases.
Court's ruling reserved till the 7th of October 2022. Hearing notices shall be issued and served on the first and second defendants.
My lord, you said on the 7th?
7 October.
Okay, it's convenient, my lord.
Thank you.
Thank you, my lord.
I must get to my lord.
Thank you. Yes, the next case, please.
National Government Service Commissions, the Chairman, Local Government Service Commission, Kaduna State, and 3, Attorney General, Kaduna State. And all parties absent.
Just a minute, please. Yes, please. That is absent. Appearances, please.
Yes,
Appearances.
I'm sorry, my lord. I didn't. I'm not sure if I got the case. I don't know if it's Kabir Adamu Rashid.
Yeah, that's it.
I'm most grateful, sir. Most grateful, sir.
Yes.
With humility to my noble lord, I am Isaac Idota for the applicant judgment creditor.
Yes.
Before this honorable court is a motion ex parte dated 21st day of March 2022, filed on the 22nd of March 2022. Subject to
Yes.
His Lordship's convener, we are ready to move same, sir.
Yes, I have issue with your prayer 3. Can you observe? Can you check it?
Yes, my lord.
Another of this honorable court to issue writs of execution and sale of the judgment debtors' properties found within the jurisdiction of this court to liquidate and satisfy the judgment debts. Well, it is of my own opinion that the sale of judgment debtors' properties is vague and ambiguous. It's either movable properties or immovable properties. You did not state what properties. And even if it is the properties, there should be a list of the properties that you want to have on sale. I think it is when you attach and you find out the properties that you want to sell, then you bring back an application that you want this property sold. That is in my own opinion.
As the court pleases, I take the hint of the court.
Yeah, so in the circumstance, I suggest that you withdraw that prayer so that I can grant you the others.
As the court pleases, in the circumstances, your lordship, I humbly withdraw prayers 3 in the face of a motion paper. I'm most grateful, sir.
Yes, application granted. Prayer 3 is hereby struck out.
As the court pleases. Most grateful, sir.
Yes. Yes, you can move the application.
Okay, I'm most grateful, sir. If all your lordship is, application is brought pursuant to order 49, those 1, 2, 3, and 6.
Yes.
Of the National Industrial Court rules and under the inherent jurisdiction of this honorable court.
Yes.
Our application prays for 3 reliefs. 1, my lord, an order for leave of this honorable court to issue the movable property as the court pleases. And number 2, order of this honorable court to issue writs of execution attaching the movable properties of the judgment debtors found within the jurisdiction of this honorable court to liquidate and satisfy the judgment debt. Your lordship, our application is supported by a 14-paragraph affidavit.
Yes.
And annexed there to your lordship are 3 exhibits marked as exhibits A1, A2, and A3 respectively.
Yes.
We place reliance on all the amendments in the affidavits and the exhibits attached, and in compliance, your lordship, it's a written address. We adopt the written address as our argument in the suit, and most humbly urge your lordship to grant our application in the interest of justice. I'm most grateful, sir.
Thank you. Court's order as prayed. Leave is hereby granted to the applicant to issue writ of execution attaching the movable properties of the judgment debtors found within the jurisdiction of this honorable court to liquidate and satisfy the judgment debts.
As the court pleases, we're most grateful, sir.
Yeah, thank you. The next case, please.
Case number 3, NICS/KD/08M/2022 between Obadiah Joseph and 1, Kaduna State University, 2, the Governing Council, Kaduna State University, and 3, the Vice Chancellor, Kaduna State University. My Lord, the claimant is present. Dependent applicant present. Judgment creditor absent. Judgment applicant absent, my Lord, present.
The judgment creditor applicant is present.
Yes, my Lord.
Yes. It's an ex parte application, so we don't expect the judgment debtor. Yes, appearances. It seems you are on mute.
May it please, my Lord, my name is Y.I. Maru. My humble appearance is for the judgment creditor applicant.
Yes.
Before my Lord is a motion ex parte dated and filed on the 19th May 2022.
What date was it filed?
19th May.
Yes.
2022, my Lord.
Yes.
My Lord's convenience, we are ready to proceed. My Lord, the motion is
yes, just like the last case. Excuse me, sir. Just as the last case that I concluded, I have issue with your prayer 5. Can you check your prayer 5, please?
Yes, my Lord. An order of this honorable court has called upon the above that the Ganeshi paid into the judgment creditor applicant's account.
Yeah, is it not after we've heard the Ganeshi, when the judgment debtor and the Ganeshis have been served with the Ganeshi Nisi and we have been asked to show cause? That is when this application is, when this prayer is appropriate.
As a copy.
Don't you think so? How can I order that they should pay the amount to you when they are forced to show cause, whether they have those amounts in their account? And okay, so in the circumstance, what do you do, sir?
We respectfully apply to withdraw prayer 5 in the said application.
Court's application granted, prayer 5 is hereby struck out. Yeah, furthermore, you might need to orally amend the amount that you quoted in your prayer 4. Yes. Have you read 29,519,195 naira, 3 kobo only, but in figure, it is 30 kobo.
Okay.
Have you seen what I am talking about?
Yes, my Lord. My Lord, in the circumstances, my Lord, we respectfully apply to amend prayer 4.
Yes.
The amount written in word, we respectfully apply to amend prayer 4 to read 29,419,195 naira, 30 kobo, not 3 kobo, my Lord.
Application granted. Prayer 4 is amended to read 29,419, 195, 3 kobo. Yes? Sorry, I didn't hear that.
The application is supported.
Yeah, I can hear now. Application is supported by?
The application is supported by a 15-paragraph affidavit.
Yes.
Deposed to by the judgment creditor applicant, sir.
Yes.
And attached to the said affidavit is Exhibit A, being
yes,
the judgment order of the Court of Appeal. My Lord, we place reliance on all the affidavits contained in the affidavits and the attached exhibit, and urge my Lord to give same as read. In compliance with the rules of this honorable court, my Lord, we equally filed a written address, which is dated and filed on the 19th May 2022. We must respectfully adopt same as our submission.
yes,
In support of this application, our release.
yes. Thank you. Court application granted. An ordinance is hereby issued against the garnishes to show cause why they shall not pay to the applicant the sum of 29,419,195 naira 3 kobo awarded in favor of the applicant. The first judgment debtor had failed and or refused to pay, and which sum now stands to the credit of the first judgment debtor in its account with the garnishee banks. The order shall be served on the judgment debtors, and garnishees shall show cause within 14 days of being served with the order. The matter is further set down till the 27th of July, 2022 for garnishees to show cause. Yes, the next case, please.
Sorry, my Lord, the returned date, my Lord.
Sorry, I thought I said it. 27th of July.
As a couple, we're very grateful, my Lord.
Yes.
/10M/2020 between Mr. Bisa A.B. Akau and Nigeria Postal Service. Other parties present.
Appearances, please. Appearances. Is she here? What's her name now? We have called the case for Bisan B. Akau and NIPOST.
Okay, I'm sorry,
Yeah.
my lord.
Yes.
I'm sorry, my lord. May it please, my lord. PN Akau
Yes.
appear for the judgment creditor applicant.
Yes.
Yes, my lord. Before my lord is a motion experte. With the kind permission of this court, we are ready to move same.
Yes, you can proceed.
Yes, my lord. The motion is dated the 28th day of June 2022
Yes.
and filed on the same date, my lord.
Yes.
Yes, my lord. It is brought pursuant to sections 97 and 98 of the Sheriff and Civil Process Act, Cap X6, S6, LSN 2004, and Order 7, Order 7 Rule 19, Order 13 Rule 28.1, and Order 11 Rule 1B of the National Industrial Court Rules 2017, and under the inherent powers and jurisdiction of this honorable court.
Yes.
Yes, my lord. We are seeking for the following orders, my lord. An order of this honorable court granting leave to the judgment creditor applicant for the issuance and service of Forms 48 and 49, respectively, on the Postmaster General NIPOST, Dr. Ismail Adebayo Adewusi, at NIPOST Corporate Headquarters, Abubakar Musa Argungu House, Plot 1279, Muhammadu Buhari Way, PMB, 12537 Garki, 90001, Abuja, Nigeria.
Yes.
Also an order of this honorable court.
The order is as stated on the face of the motion paper. You can proceed.
As the court pleases, my lord. We have also filed a 4-paragraph affidavit.
The grounds on which the application is predicated is also as stated.
Yes, my lord. We also filed a 4-paragraph affidavit. Attached to the affidavit are 2 annexures, my lord, marked as the exhibit BA and BB. We rely on all the averments in the affidavit, my lord. Also, in compliance with the rules of court, we have equally filed a written address, and we rely on all the submissions, my lord, as our arguments. We pray, my lord, grant all the reliefs as stated on the face of the motion paper in the interest of justice. Thank you, my lord.
Thank you.
Yes, my lord.
Court order as prayed. It is hereby ordered as follows.
Yes,
1, leave is granted to the judgment creditor applicants to issue and serve from Form 48 and Form 49 on the Postmaster General NIPOST, Dr. Ismail Adebayo Adewusi at NIPOST Corporate Headquarters, Abubakar Musa Argungu House, Plot 1279, Muhammad Buhari Way, Gariki, Abuja. 2, to serve Form 48 and subsequently Form 49 by substituted means, to wit, by effecting the service of the said forms through courier service, and to evidence the proof of service of same. The said mode of service on the judgment debtor shall be deemed as good and proper service. 4, to substitute the judgment creditor, now deceased, with Mr. Isaac A. Akau and Mrs. Rachel A. Adwa, who are now lawful administrators.
As the court pleases. I'm most grateful, my lord.
Thank you.
Thank you. Most grateful, my lord.
Yes, the next case, please.
Case number 5, NICS/KD/21/2022, the two Aruna. When the ends, DJ, Dynamics Synergy Security. My lord, parties absent.
Parties absent, appearances, please.
Respectfully, my lord, Umar Musa is my name.
Yes.
Umar Musa is my name.
Yes.
The humble appearance is for the plaintiff, my lord.
For the claimant, you mean?
Yes, my lord.
Yes, any representation for the respondent?
With respect, my lord.
Yes.
I'm O.J. Babajide. I humbly appear for
O.J. Babajide.
Yes, my lord.
For
the defendants.
Defendants. Yes.
Yes,
Mr. Umar.
Before my lord is our motion ex parte.
It cannot be motion ex parte again. You've put them on notice and they've replied.
I stop. Before my lord is on notice.
Yes.
Dated the 21st day of June 2022.
Yes.
And filed on the 24th day of June 2022, my lord.
Yes.
Now the motion is brought pursuant to Section 1 sub 3B of the National Industrial Act and Section 7 sub 1 of Men's Compensation Act 1987.
Yes.
And Section 2 sub 1B of the Factories Act and under the inherent jurisdiction and sanctions of this honorable court.
Yes.
My Lord, on the face of our motion, there are two prayers contained therein.
Yes.
My Lord, the first prayer is an order of this honorable court for an order of mandamus, compelling and directing the respondent to pay the applicant the total sum of 1,065,000 naira for medical financial implication, 700,000 naira for maintenance pending recovery, and 200,000 naira for miscellaneous.
Yes.
My Lord, the last prayer is an omnibus prayer. There are 9 grounds upon which this application is brought, my Lord.
Yes.
My Lord, there is affidavit annexed to our motion with 27 paragraphs, deposed by one Musa Zubairu Okikilo.
How many paragraphs affidavits?
27 paragraphs, my Lord. We place heavily reliance on all the abaments contained therein.
Yes.
My Lord, there are 4 exhibits attached to our affidavit.
Yes.
My Lord, to be specific, exhibit AA1 is a letter written to the Department of Surgery, Ahmadu Bello University Hospital, Shikazaria.
Yes.
Exhibit B, my Lord, is the reply of the Department of Surgery of Ahmadu Bello University Zaria to our letter.
Yes.
Lord, exhibit AA3 is the demands notice written by a legal practitioner to the defendant.
Yes.
Exhibit AA4 is the photograph of the claimant, my Lord.
Yes.
My Lord, in compliance with the rules of this court, we have filed written address.
Yes.
My Lord, we adopt same as our oral argument and our submission in this case.
Yes.
And we urge, my Lord, to grant our petition as prayed.
Yes, thank you.
I'm most grateful, sir.
Yes, Mr. Babajide.
Thank you, my Lord. My Lord, in opposition to the claimant's application, we filed a 15 paragraphs counter affidavit. We filed a 15 paragraphs counter affidavit.
Yes.
Attached to our affidavit are 4 annexed TP1, TP2, and TP. And we've equally filed a written address in compliance with the rules of this court, which is dated the 30th of June, 2022. May we
Yes.
to dismiss the application with cost.
Sorry, I lost you for a while because your network went off for a while. So we have filed a written address.
My Lord, we filed a 15 paragraphs counter affidavit.
Yes, I heard that.
We place reliance on all the environment as contained in the counter affidavit. Attached to our counter affidavit are 4 annexures marked exhibit TP, TP1, TP2, and TP3.
Yes.
And in compliance with the rules of this court, we've equally filed a written address dated the 30th of June 2022.
Yes.
May we humbly apply to adopt the said written address as our argument in support of our counter affidavit in urging this honorable court to dismiss the claimant's application with cause, sir.
Mr. Omau, you did not file a reply?
As a purpose.
My Lord, we intend to reply on point of law as we were served very late yesterday.
Okay, you can go ahead.
My Lord, by way of reply on point of law.
Yes.
The counter affidavit of the defendant.
Yes.
Is against the weight of evidence.
Is against the weight of evidence.
And contradicts the entire provision of Section 84 of the Evidence Act.
Entire what?
Section 84 of the Evidence Act 2011.
Yes.
May we humbly at this point refer my noble Lord to the case of Kubo and another versus Dixon and others.
So in what way did you say it has contradict? Which of the paragraphs or what evidence is in contradiction, please?
My Lord, Exhibit TP2, which is a computer-generated evidence. TP2.
TT2?
TP2.
It's a computer-generated evidence.
Yes, my Lord. It's only a screenshot of the profile of a legal practitioner. It's only a screenshot of the profile of a legal practitioner.
Okay.
It's only a screenshot of the profile of a legal practitioner.
Yes.
WhatsApp profile, my Lord. It's a screenshot of legal practitioners' WhatsApp profile.
Yes.
My Lord, TP3. TP3.
Just a minute.
A purported document is a purported.
Yeah, TP3 is what?
It's a purported document formed from Corel Draw of a computer. It's a purported document formed from Corel Draw computer. From a Corel Draw of a computer.
Well, the TP2 that you referred to, how many copies were you given?
Sorry, my Lord.
The TP2, apart from bringing a profile, you said it's a profile?
Yes, my Lord. It's only a screenshot. It's a screenshot of the profile of a legal practitioner's WhatsApp.
But there's another letter with a PDF, reply letter. What are you saying about that? That says, good day, we are solicitors to BJ Synergy. Did you have that?
My Lord, is the letter we are saying is purported, and it was formed from a Corel Draw of a computer.
Okay, have you read their counter affidavit stating that they had complied with Section 84?
My Lord, we are saying that all what they exhibited in the counter affidavit that they comply with Section 84 is against the holding of Dixon against Kubo, as cited supra.
Okay.
Foundation has been made by the defendant country.
Okay. Yes.
You're allowed to be specific in Dixon. My Lord said, court has no evil eye to detect such a trick getting from a computer-generated evidence.
Okay.
unless their foundation has been laid by the defendant. The court has no eagle eye to detect a breach.
Yes.
And we are saying that CP3 is a purported document from a Corel Draw of a computer.
Yes.
That only the name Musa Umar ESQ was formulated by the defendant and fixed it at the top of the letter of the defendant as a reply.
Okay. Mr. Babajide, are you with Techno Network?
Yes, my lord.
It's indicating on my side that the bandwidth is low. So, yes, Clement Cancel, are you done with your submissions?
My lord, in view of the foregoing,
yes,
we are of the view that the defendant is only trying to escape from a locality risk theory.
That is your submission in your main address. Are you re-arguing this?
No, my lord, we are not re-arguing, only that we want to give my lord another case that will give a word to the other case we supplied in our written address.
Yes.
We refer my noble lord to the case of Tanko Mekujeri.
On what issue is that?
The same locality risk theory, my lord.
Refers the court
to Tanko Mekujeri.
To Tanko what?
Mekujeri as in M-A-I-K-U. M-A-I.
Yes. Yes.
K-U-J-E-R-I.
Yes.
Versus provincial engineer.
Provincial?
Engineer.
Okay.
A-B-C-D-E, my lord.
Yes.
1976 NCLR.
1976?
Yes, my lord. NCLR.
Yes.
At 441.
Yes.
My lord, I beg to paraphrase the holding in that case.
Yes.
In those cases where it is necessary to consider whether a particular employment by its circumstances involves special liability to a risk, which is in its nature general, the contrast is between persons engaged in the particular employment or under the particular circumstances and persons not employed under the same circumstances. My lord, we are saying that in the counter affidavit of the defendant, they admitted that the claimant is their staff. We submit that.
Yes.
We submit with respect that the defendant admitted that the claimant is their ad hoc staff.
Yes.
In paragraph 3D of the defendant counter affidavit.
Yes.
We urge my noble lord to so hold.
Yes.
And grant our prayers. We are most grateful, sir.
Yeah, thank you. Ruling. Ruling of the courts on this application is as follows. The instant application was filed by the applicant on the 24th of June, 2022 for an application for judicial review by way of mandamus against the respondent, the defendant respondent. The application seeks, I quote, an order of this honorable court for an order of mandamus compelling and directing the respondents to pay the total sum of 1,065,000 naira only for medical financial implication, 700,000 for maintenance pending recovery, and 200,000 for miscellaneous. To support the application, the applicant relied on the statement setting out the grounds upon which the application is brought, an affidavit of urgency verifying the facts. The applicant further filed a written address of legal argument to further support the application. To oppose the application, the respondent on the 1st of July 2022 filed a counter affidavit of 15 paragraphs, equally accompanied by a written address of learned counsel's legal arguments in opposition. I have proceeded to examine the totality of the processes filed by the parties in pursuance of and to oppose the instant application, and also given a careful consideration to the written and oral arguments canvassed by learned counsel on both sides to back their respective contentions. As deposed in paragraphs 2 and 3 in the affidavit of Musa Zubeiru Okikilo, the applicant is a security agent of the respondent, a company registered under the Company and Allied Matter Act, CAMA. The respondent made reference in paragraph 3D of the counter affidavit that the applicant is an ad hoc staff whose services is required on contract basis whenever the need arises. It is narrated on behalf of the applicant that on the 3rd of May 2022, while on night duty at the premises in vicinity of the respondent, the applicant sustained an injury, after which he was rushed to One Ladia Hospital and the respondent deposited the sum of 10,000 naira as his medical bill. That the applicant was thereafter referred to Ahmadu Bello University for further treatment, that the hospital was given the applicant a bill of 1,065,000 naira for his medical treatment, and that a demand notice was written to the respondent for the payment of the applicant's medical bill. The applicant has alleged that the deponent has alleged that the applicant is a very poor man, indigent, and less privileged to take responsibility for his medical bill. It is further alleged that the respondent has been evading responsibility despite the demand notice. The foregoing represents the brief facts of this case as narrated on behalf of the applicant in the affidavit deposed in support of the application. In the counter affidavit filed on its behalf, the respondent denied the substance of the applicant's claims in its entirety. As a matter of fact, the respondent denied in paragraph 3, H, I, J, I, M, K, and K of its counter affidavit that on 3rd May 2022, there was no incidence of break-in by unknown men, nor was the applicant attacked or injured by unknown men in the course of his duty. That no physical injury or bruises was found on the body of the applicant, and that the medical examination conducted on the applicant at Lydia Hospital, he was diagnosed to have an acute spondylosis of lumbar sacral region with nervous involvement causing urinary retention. These depositions the claimant did not file any reply to these depositions as to the ailment of the applicant. From the depositions made on behalf of the respondents in the counter affidavit, it becomes clear that the respondent is denying liability in any sum for the medical expenses of the applicant, and particularly since it has no public duty to the applicant to pay for his medical expenses. Now, In the determination of this case, I shall adopt issue 1 as raised by the learned respondent counsel in his written submission. The real issue as correctly submitted by learned counsel is whether the Honorable Court has the power to grant the application of this nature. In resolving this, I will take an excursion into the law on mandamus and the circumstance and condition upon which the order of mandamus can be made, and whether in the facts of the case before this court, the order of mandamus can be granted. In simple terms, an order of mandamus is one issued by a court of law to compel the performance of a public duty in which a party has sufficient legal interest after refusal, failure, or neglect to do so on demand, where a public officer or institution is vested with the authority, power, or mandate by statute or the subsidiary legislation to perform a public duty or function of a public nature, and refuses to perform or carry out that duty or functions without cause after demand by a person who has sufficient legal interest in the performance of such duty or function, or order may issue from a court of law to compel the performance of the duty or function in question upon fulfillment of certain conditions. The emphasis is a public officer performing public function. See the cases of Controller General Nigeria Customs Services in another versus Minaj Holding Limited, Dairo versus Stanbic Bank, IBTC Bank, and another citation supplied. See also the case of Fawahime versus IGP, 2007 Nigeria Weekly Law Report, part 665, page 481, where mandamus is described as follows at page 674 to 675. I quote, mandamus is a high prerogative writ which lies to secure the performance again of a public duty, in the performance of which the applicant has sufficient legal interest. It gives a command that a duty or function of a public nature, which normally, though not necessarily, is imposed by statute, but is neglected or refused to be done after due demand be done. If there is discretion in the performance of the duty, the court has the power to examine whether the discretion to refuse the act has been properly exercised. In the exercise of the power, the court will not lightly overrule the discretion just because it considered it desirable that the duty be performed. Even if it is found that the discretion was not properly exercised, or that there was in fact no discretion at all in the matter, the court may still exercise its discretion not to order mandamus on the ground, on the general ground, that the court will not make no order in vain, which could no longer be carried out on the ground of expediency, that it will serve no useful purpose, even if the order were implemented, end of quote. Following the above decision, it was restated in Anthony versus Governor of Lagos State, 2003, 10 Nigeria Weekly Law Report, part 828 at 288, that, I quote again, it is settled that where a person or body has a duty of public nature to perform or discretion of a public nature to exercise, order of mandamus can be issued to compel the performance of the duty or exercise of discretion, provided a request to do so preceded it. End of quote. The prerogative writ of mandamus is issued or ordered by the courts to secure or enforce the performance of a public duty. It is preeminently a discretionary power, and the courts will decline to award it if other remedies are available and effective. An applicant for the grants of the other must show that he has sufficient legal interest to protect and that he has demanded the performance of the public duty from those obliged to do so and was refused. In the case at hand, it is not at all in dispute that the respondent is a private limited company. As such, I cannot but agree with the learned respondents' counsel that the writ of mandamus cannot be granted to enforce the performance of an obligation held by a private company towards its employees. The applicant has not satisfied the condition for the grant of the application, and I so hold. Perhaps I should deal briefly with learned applicant's reference to the repealed Workmen's Compensation Act. The current law is the Employee Compensation Act 2010. It is wrong to refer to a repealed law in the way learned applicants' counsel did. A repealed law no more has legal life, as it does not exist any longer. It cannot be cited as if it still exists. If it must be cited at all, it must be cited as a repealed law, which has no life to influence an argument. The entire submission of learned counsel on the repealed law is hereby discountenanced. In the final analysis, this application is incompetent and same is hereby refused. Parties shall bear the respective cost of this action.
As a copy, we must go, my lord. Go to my lord.
Yes, in the event that your application has been refused, I think the proper thing to is to strike out this case, because your statements of facts, the reliefs that you are asking, is the same as is contained on the mandamus. The applicant's case is hereby accordingly struck out.
As the court please.
As the court pleases. We're most grateful, my lord.
Thank you.
Yes,
the next case, please.
Case number 6, NICS/KD/31/2020 between Omar Mohammed Jamu and Kaduna State Independent Electoral Commission. The parties absent.
Yes.
May it please this honorable court, I am Prince Anyuku for the claimant, my lord.
Did you say the parties are absent?
Yes, my lord.
What's the name, sir?
Prince Anyuku, my lord.
Your appearance is for the
claimant, my lord.
Yes, defense. No representation for the defense.
Milord, she's trying to connect. I think her network is. Barrister Damo, are you there?
Is she online now?
Yes, my lord.
She's raising her hands or something. Let's see what she's saying. Yes, Miss G. Adamu for the defendants. Are you online now? Yeah. G. Adamu for the defendants. Are you online now? Yes. Do I continue?
Milo, she sent a message that a chat that she can't hear anything.
That she cannot hear me?
Yes, ma'am.
But I replied that I told her that she should unmute her speakers. I
She
saw the.
No.
Okay, I'll continue. She'll join us anyhow.
Okay.
Judgment. The claimant at all times material to the suit was the principal executive officer of the defendant until his appointment was terminated. The case of the claimant, briefly stated, is that the purported disciplinary procedure adopted by the defendant, which culminated into the termination of his appointment, was not in compliance with the guidelines for appointment, promotion, and discipline of officers issued by the Kaduna State Civil Service Commission 2005. The claimant further contends that he was not given the opportunity to be heard, and thereby the termination of his appointment was in breach of the principles of natural justice. It is on the basis of those essential facts that the claimant instituted the instant action by the complaint and statement of facts filed in this court on the 31st of August 2020, and by amended statement of facts filed on the 31st of August 2021, pursuant to order of this court made on the 18th of October 2021, he claimed against the defendants the reliefs set out as follows. One, the reliefs is stated, they are stated on the face of the judgments. 10 reliefs therewith. I'll skip it to save the time of the court.
As the court please.
The defendants denied the claimant's claims and joined issues with him thereupon by filing the statement of defense on the 10th of September 2020. The defendant contended that it investigated the allegations of misconduct and illegality leveled against the claimant in accordance with the defendant's extant guidelines and laws before his appointment was terminated. The defendant went on to further contend that the claimant admitted committing the misconduct and that he pleaded for the reversal of the termination of his appointment, whereof the defendant denied. Excuse me, just a minute. Sorry, I needed to charge my laptop. It was the battery was running low. So whereof the defendant denied liability to the claimant's claims. On the 18th of October 2021, after the close of pleadings, learned counsel on both sides by consent, pursuant to Order 38, Rule 33 of the rules of those courts, adopted the procedure of trial on records. By the said procedure, the present case shall be determined on documents front-loaded, thereby dispensing the need for trial by oral testimony and or cross-examination. The court has taken liberty to remark the documents annexed to the pleadings as exhibits. As prescribed by the provision of the said rule, parties, starting with the claimants, were ordered to file and exchange their written final addresses. In the final address, filed on the 8th of November 2021, Learned Counsel for the claimants, Sanusi Musa Esquire, formulated a sole issue as having a reason for determination in the suit, that is, not given the circumstances of this case, the termination of the appointments of claimants by the defendant is in accordance with the provision of the law. On behalf of the defendant, G.E. Adamu Esquire of counsel, filed the final address deemed filed on the 27th of April 2022, wherein two issues were formulated as having a reason for determination in the suit, namely, one, whether or not the defendant has the statutory powers to discipline any of its members, and two, whether or not the claimant has proved his case to be entitled to judgment in the suit. In the light of the reliefs claimed by the claimant, the documentary evidence on record by both parties, and the field of disputes between the parties, it is my view that the focal issues that have a reason for determination on the suit, without prejudice to the issues already formulated by learned counsel on either side, can be succinctly framed as follows. One, whether or not the defendant complied with the provisions of its laws, statutes, and guidelines in terminating the claimant's appointment. Two, upon resolution of issue one, whether or not the claimant lawfully establishes his entitlements to the declaratory reliefs and other reliefs claimed in the suit against the defendant. In proceeding to determine those issues, I must state that I had carefully considered and taken due benefits of the totality of arguments canvassed by the respective learned counsel in the written final submissions, to which I shall endeavor to make specific reference as I consider needful in the course of this judgment. From the evidence on record, it is stating the obvious to affirm from onset that the employment relationship between the claimant and the defendant is regulated by statute. This is clearly seen in that the defendant, by paragraphs 1 and 3 of the statement of defense, positively admitted the averments in paragraphs 1, 2, and 3 of the claimant's statement of fact. The claimant's letter of probationary appointments, letter of permanent appointments, acceptance form, and notification of promotion respectively admitted as exhibits C1, C1A, C1B, and C1C. Further, buttress that the employment of the claimant is statutory, which conferred him with a legal status higher than an ordinary master-servant relationship, and his employment could only be terminated in the way and manner prescribed by the statute establishing the defendant on the regulation made under it. The defendant's guideline for appointments, promotion, and discipline is admitted as Exhibit C2. According to the claimant, his ordeal began when he was making preparation for the election that was scheduled on the 12th of May 2021. He recounted that he got information from one Kabiru Mohammed McAfee, an electoral officer, about an impending attack. That, based on the information, he took the result sheets of the chairman and councillor in his custody to an internal revenue office for safekeeping. That he was accosted and kidnapped by unknown armed men on his way back to the office, and they demanded for the whereabouts of the electoral officer and the results sheets. That after he was released by his abductors, he went to the police station and submitted the sensitive materials to the DPO and the electoral officer, and they both confirmed that the documents had not been altered. The claimants further stated on the 21st on May 2018, he wrote Exhibit C3, a detailed report to the secretary of the defendant, stating the reason he was detained by his abductors. The claimant further relied on Exhibit C4, the first information report, and Exhibit C5, the record of proceedings at the Chief Magistrate Court, to establish that he was arraigned with two other officers for the offense of theft but that the defendant wrote Exhibit C6, a letter dated 22nd of June 2018 to the Commissioner of Police to withdraw the case from the court. The claimant stated that he received a query from the defendant and that he promptly replied the query. Query dated the 15th of November 2018, and the claimant's reply to the query dated 16th of November 2018 are respectively admitted as Exhibit C7 and C7A. Now, the crux of the claimant's case is that the procedure for the termination of his appointment was in violation of the guidelines stipulated by the defendant in Exhibit C2. The alleged breaches of procedure according to claimants are as follows. 1, unknown to the claimant, the defendant on 18th of August 2019 held a special meeting of Human Resource and Corporate Governance Committee of CAD-SECOM on electoral officers with outstanding disciplinary cases. Minutes of the meeting of Human Resources and Corporate Governance Committee is admitted as Exhibit C8. 2, the meeting was conducted and concluded contrary to the guidelines for discipline of government officials as provided by Exhibit C2. C, on the 20th of May 2019, the defendant issued a termination of appointments, a letter of termination of appointment, that is Exhibit C9 to the claimant, stating that in the interest of general public, a service was no longer required. 4, surprised by the conduct and clear violation of the guidelines stipulated in Exhibit C2, the claimant began to exploit amicable means for the reversal of unlawful and unwarranted termination of his appointment. Another letter dated 27th of May 2019, that is Exhibit C10, was written by the defendant to reaffirm the termination of his appointment. 5, his employment being clothed with such statutory favor cannot be terminated without following due process as provided by the statute. Then 6, the procedure adopted by the defendant is in breach of principles of natural justice required of an administrative body. The defendant's admission in paragraphs 11, 13, and 14 of the statement of defense is that the claimant wrote Exhibit C3 to report the incident of 12th May 2018, that Exhibit C6 was written to the Commissioner of Police to withdraw the criminal case instituted at the Chief Magistrate Court, and that the claimant was subsequently issued with a query. The defendant further stated that a disciplinary action was commenced against the claimant because the reasons he gave in his reply to the query were unsatisfactory. The defendant maintained that he complied with the provision of the law in terminating the claimant's appointment. The defendant stated further that after the claimant's appointment was terminated, he wrote a letter dated the 24th of May 2019, that is Exhibit D1, to plead for forgiveness and reversal of the termination of his appointment. Now, with reference to Exhibit C2, Learned Claimant's Counsel submitted that the defendant is required to comply with the procedure for disciplinary action against its officers, such as the claimant in the present case. Learned Claimant's Counsel argued that having been discharged by the court of the criminal charges, the disciplinary action against the claimant must be commenced by first seeking and obtaining the opinion of the Attorney General. Learned Counsel argued that the procedure adopted by the defendant without complying with the guidelines as required in Exhibit C2 is illegal, null and void, and of no effect whatsoever, and inconsistent with the claimant's condition of service. To buttress his submission, Learned Counsel cited the case of Psychiatric Hospital Management Board versus Ejichata, 2000, Law Pavilion Electronic Law Reports 229 and 30. On the flip side, the argument of Learned Defendant's Counsel is that the power of the defendant to discipline its officers, inclusive of the claimant, is vested in Part 3, Section 2 of Kaduna State Electoral Commission Law, Number 2 of 2018. Learned Counsel argued further that for the purpose of disciplining the claimant, the CADSEC law alongside the Public Service Rules of Kaduna State 2005 was invoked by the defendant, upon which the committees set up to hear the claimant's case gave recommendation for the termination of his appointment. Learned Counsel also argued that based on the apology and plea for the reversal of the termination of his appointment in Exhibit D1, the claimant had admitted to the acts of misconduct and no further proof is required by the defendant to establish that the termination of his appointment was unlawful. It is the further argument of learned defense counsel that by the issuance of the query on the claimant's opportunity was given to him to be heard and defend himself, and the claimant and the court cannot foist an employer the services of an employee. Learned Counsel cited the cases of Imohe versus Unity Bank and New Nigeria Bank versus Idigbe, citation supplied. Now from the totalities of the evidence, adduced by the claimant, could it be said that he has satisfactorily established his appointment, that his appointment was unlawfully terminated by the defendant as alleged to entitle him to the reliefs he claimed? Parties are added in that Exhibit C2 is the guidelines for appointments, promotion, and discipline issued by the defendant in 2005. Parties are also not in contention that the claimant and two other officers were charged at the Chief Magistrate Court, after which the case was withdrawn by the defendant and the claimant was discharged. The submission of Learned Claimant's Counsel is that the defendant did not comply with the procedure of terminating the employment of officers such as the claimant who has been discharged of a criminal charge by the court. In view of its relevance to the determination of this case, I find it necessary to refer to the relevant provisions of Exhibit C2 in relation to the guideline or procedure for the discipline officers of the defendants, such as the claimant who was discharged by the court on criminal charges. Paragraph 1, page 23 of Exhibit C2 states, I quote, "In the event of the acquittal or of the discharge, whether amounting to acquittal or not, of an officer who has been charged with a criminal offense, the Director of Administration shall consider whether he should recommend the institution or continuance of disciplinary procedure against such officer. But before recommending the institution or continuance of disciplinary procedures in pursuance of this rule, he shall, after consultation with the permanent secretary, refer the matter to the Attorney General of the state for an opinion as to whether or not disciplinary proceedings can be properly be instituted or continued under these guidelines. In the event of a discharge which does not amount to acquittal, the Director of Administration shall ascertain from the Attorney General of the state that further criminal proceedings against the officer are not proposed." End of quote. By my understanding, the procedure for the institution of disciplinary proceedings against such officers as the claimants by the defendants in Exhibit C2 is that before the Director of Administration shall consider whether he should recommend the institution or continuance of disciplinary proceeding against such officer, he shall have consulted with the permanent secretary, after which the matter shall be referred to the Attorney General of the state for an opinion as to whether or not disciplinary proceedings can be properly be instituted or continued under the guidelines. The argument of Learned Defendants Counsel is that by the provision of Rule 04103 of the Public Service Rule of Kaduna State, the power of the Civil Service Commission has been delegated to permanent secretaries and heads of extra-ministerial departments, and that the defendant acted rightly through the secretary and or chairman in accordance to the public service rule by issuing the claimant's letter of termination of appointment. This argument is clearly beside the point. The grouse of the claimant is not on the authority to whom power is vested to terminate his appointment, but on the procedure adopted by the defendant in terminating his appointment, which procedure is faulted as unlawful for its non-compliance with the guidelines as prescribed by Exhibit C2. Going further, the argument of learned defendants' counsel on delegation of powers is equally faulty. Rule 04103 of PSR, Kaduna States, Chapter 4 on discipline provides that the rule should be read in conjunction with guidelines for appointments, promotion, and discipline issued by the Civil Service Commission, that is Exhibit C2. It is elementary that where a statute has prescribed the mode of performing a duty or taking a particular action, it will be an anomaly to condone or adopt any other methods to the contrary, whether done deliberately or by inadvertence. It will be improper to insist that such anomalous situations should be acted by a court in its decision. See the cases of Emirates Airline versus Federal Republic of Nigeria and others, case of Incorporated Trustees of United Visionary Youth of Nigeria versus Shokubo, citations applied. From the evidence on records, it is glaring that the defendant did not adopt the procedure prescribed in Exhibit C2 in terminating the appointment of the claimant, and I so hold. The grievance of the claimant against the defendant is also that he was not given the opportunity to defend the allegation leveled against him. According to the claimant, he had denied the allegations leveled against him and has sufficiently stated the reason why disciplinary action should not be taken against him in his reply to the query, and he was not aware that a special committee was set up to investigate him. The further submission of learned counsel for this claimant that the power of the defendant to hire and fire under Section 12(1) of the Kaduna State Electoral Law 2018 does not exclude it from the observance of rule of natural justice in terminating the appointment of his employees. The argument of the learned defendant's counsel is that the claimant had pleaded for the reversal of the termination of his appointment in Exhibit D1 and thereby admitted committing the offense. With due respect to the learned defendant's counsel, this submission is a total misconception of the law. Exhibit D1 cannot, by any stretch of legal imagination, regarded as admission of guilt to cover for the defendant's non-compliance with the prescribed procedure for terminating the claimant's appointment. As can be gleaned from Exhibit D1, it was written by the claimant after his appointment was terminated by the committee, and as such, it cannot be regarded as admission. The pith and substance of the instant case is that the claimant's appointment was arbitrarily determined outside the purview of law and the conditions of his service with the defendant. The clear evidence on record is that a decision to terminate the claimant's appointment was made by the committee set up by the defendants to investigate the claimant without inviting him to defend the allegation. The argument of defendant's learned counsel that the claimant had been given the opportunity to defend himself by the issuance of a query is untenable without proof that the claimant was invited to the special committee that investigated the allegation. Based on the foregoing, therefore, I am satisfied that the termination of the claimant's appointment was not in accordance with the law, and I so hold. Having held
As the court pleases.
that the defendants did not strictly and fully comply with the provision of this Exhibit C2, the purported termination of the claimant is hereby set aside as same is unlawful, null, void, and of no effect whatsoever. I so further hold it is right that where there is an improper removal of an employee from an employment protected by statute, the consequence is that the employee has not been removed from office. In other words, once dismissal or termination of employment is declared null and void, there is nothing legally standing in the way of the employee from having his or her job back with its attendant rights, benefits, and privileges. In such a situation, the court has the power to set aside the unlawful termination or dismissal and order the reinstatement of the employee. See the cases of Visitor Imo State University and others versus Professor Konkwa and others, Kwara Polytechnic Ilorin versus Oyebanji, Omidiora versus Federal Civil Service Commission, citations also applied. The same principles are fully applicable to the claimants in this case. In the circumstance, therefore, having found that the termination of the claimant's appointment was unlawful, the claimant is entitled to the consequential relief of reinstatement and payment of his outstanding salary from the time of unlawful termination of his appointment. In the final analysis, standing on the solid position of the law, I hereby grant the claimant the following reliefs. 1, it is hereby declared that the decision taken by the defendants to terminate the claimant's appointment at the special meeting of Human Resource and Corporate Governance Committee of CAD-SECOM on the 15th of May, 2019 is illegal, null, and void, and of no effect whatsoever.
As the court pleases. 2,
it is further declared that the termination of the claimant from the service of the defendant by letter of termination dated 20th of May, 2019 is unlawful, null, and void, and of no effect. 3, another of this honorable courts setting aside the defendant's letter dated 20th of May, 2019 with reference number SACOM/KD/SS/PR.96/29 terminating the claimant from the employment of the defendant. 4, another of this honorable court restating the claimants to the position of Principal Executive Officer 2 in the service of the defendant. 5, another of this honorable court directing the defendant to pay within 1 month all salaries, allowances, and other employment benefits accruing to the claimant from 20th of May 2019, the date of the termination of his appointment till date. 6, parties shall bear their respective costs.
As the court pleases.
As the court pleases. My Lord, we are most grateful for your well delivered ruling.
It will be well delivered when it is always in your favor. I want to hear that when you're on the defense side. When I deliver
we
the
always
judgment.
say that, my Lord.
Okay, I'll wait. I'll wait for you. By God's grace, you will come as a defendant before me, and I will wait for this comments if the judgment is not in your favor.
Yes, my Lord.
Yeah, the court. Counsel, we want to confirm from you, you did not submit the originals of these documents that were next to your pleadings.
My Lord, I'll have to confirm from my.
Yeah, because you said you front-loaded the documents in line with the order of the courts of Order 38, Rule 38. You were not required to submit the originals, because I asked one of the registrars to confirm from you, but she said she didn't get a positive result from you. So we want to confirm that the originals were not submitted to us. Thank you. Please liaise with the registry to confirm, please.
All right. Thank you, my Lord. I'll do that, my Lord.